We're excited to have back again Rob Silverman, attorney, Robert J. Silverman, attorney in probate here in the state of California. And since we've met a couple times today, I decided we'd take a chance to maybe go into some advanced topics that real estate agents and petitioners, executors, administrators, fiduciaries, vendors should know about. And we have a real live attorney, though he's not representing us or giving us legal advice, he can help us understand the process and explanation. So Rob, thank you for joining us again today.
Thanks for having me again, Bill.
Okay, so let's jump right into it. Let's talk about spousal petitions. Oftentimes I'll see a situation where there's an argument, is it a spouse, it's not a spouse, were they married, were they not married, is there a will, not a will, and people say, oh no, it's easy, we don't need a probate, we just need to do a spousal petition. I would say, well, that isn't easy, it's different, it's a different document. Talk about a bit about the options of spousal petitions versus a standard probate.
Sure. So if somebody was married and passed away, and let's say they died intestate, they died without a will, and let's suppose, like a lot of married couples, all their assets were acquired during the marriage. Neither spouse brought anything into the marriage and kept it separate. Neither spouse inherited, or at least the deceased spouse, the first spouse to die, didn't inherit anything during the marriage or receive anything by a gift. Those are all sort of separate property. So everything was acquired during the marriage, and everything is community property. Community property, dying without a will, community property goes to the spouse. And you'd say, well, fine, do a probate, and at the end of the probate, then all that, the community property, which is the 50% that was owned by the deceased spouse, will end up going to the surviving spouse. So 50%, there's $1 million of assets, and $500,000 of it belong to the deceased spouse. That has to go through probate, right? No, wrong. A spousal property petition is what it's called, is filed or can be filed, and you basically petition the court. It's not, you don't follow the same rules as a probate, but you file a petition with the court alleging that the deceased spouse owned these assets as community property, and they should be confirmed to belong, the 50% that belong to the deceased spouse should be confirmed to belong to the surviving spouse. There's a hearing that's set, depending on the court, a lot of different courts in California, depending on the county. It's a couple months to 6 months. And whenever the hearing takes place, if everything is in order, the judge issues an order that says, yes, the 50% of the community property that was belonged to the deceased spouse is now owned by the surviving spouse. Done. No publication, no notices, no creditor claim process, no inventory and appraisal. All the typical things that need to be done in probate don't have to be done. Simple. It's relatively simple notice petition, and it's not nothing, but it's a lot less expensive typically than a probate. Even if there's significant separate property, well, so that's the basic, Bill. There is, and somebody might say, well, what if the deceased spouse owned a bunch of separate property too? Well, then there probably has to be a probate, because not everything can be confirmed to the surviving spouse unless there was a will. If there's a will that says all of my assets go to my spouse if I die first, then not only community property, but separate property can, under the will, be done by spousal property petition.
So assuming a surviving spouse files an 850 petition, gets the court to confirm that all the assets are in fact community property, does the court then issue an order, and is that able to be used to grant property or sell property or transfer title, or what's the process look like to actually get the title transferred to the name of the surviving spouse?
Yeah, good question. So it's similar to a probate in that when you have real property and you have the final order in a probate, that order gets recorded, and that serves just like a deed. Right. The final order that says the spouse is entitled to this or that piece of real property in a probate petition, it's the same with a spousal property petition order, and that is similarly recorded, and then it is effectively like a deed in that the surviving spouse is then cleared to refinance, sell, do anything that any other owner of real estate can do.
Now, you mentioned it's less expensive than probate, but it's not free. Meaning, if you have $1 million property, a probate might cost $10,000, $20,000, $25,000 or more. You have legal fees and expenses, and depending on an 850 petition, it might be maybe, my experience, about half of that, but still a substantial amount of money. Does that sound about right as a general rule?
It really depends a lot. I mean, attorneys have different rates throughout the state, and some do these on a flat fee basis, some do on an hourly basis. But I would say a reasonable range for a spousal property petition, if everything else, there's no sort of weird facts and anything strange going on, is going to be anywhere from, call it, $3,500 to $7,000 or $8,000. Now that's a big range, but there's a big range of experience and fee bases by attorneys. But in any event, yes, to your point, it doesn't take, based on the statutory fee formula, it doesn't take a real large estate to get well above 10,000, 15,000, 20,000, and it would be unusual, even for very expensive attorneys, to charge that for a spousal property petition.
And typically, these matters are heard in the same courts where probate are. Like in LA County, it's in the probate court. So in essence, you're in probate court. You're just not, the material is a spouse petition as opposed to a probate case or the petition. But really, at the end of the day, it's you're paying maybe half the price, but something, and you're in the same building in front of the same judge, hiring an attorney to kind of do the same thing. So oftentimes to customers, when they say, well, it's not a big deal, well, it's not a big deal unless it's a big deal, right?
Yes. If you think of it just as a simplified process that's less expensive, it takes a lot. Just even if the fees aren't hugely different, the procedure is involves a lot less bureaucracy and takes a lot shorter period of time typically.
Now, it's shorter once you're there, but at least in LA County, when you file the 850 petition, your first hearing date is not for 6 months.
Right.
On a probate, theoretically, with full authority, you can get it approved in 35, 40 days, get your order, and sell the property and close escrow before then. So again, it's different. I think this is where clients really need to sit down with the attorney, and you're laying this out. But I think it's really important to get your clear plan. What are you trying to do? And so given that it would be faster in some cases to do a probate than a spousal, does one have the option to probate as opposed to a spousal petition, or is that not appropriate?
Yes, absolutely you have the option. There are rare cases where even though it's going to be a little more expensive and it's going to take more time, it's appropriate and helpful to probate something. For example, there's a creditor's claim period in probate, in a full probate, where once the petition is granted for probate and letters of administration or letters testamentary are issued, there's a 4-month creditor's claim period. If known creditors are notified and and they don't file a claim, and unknown creditors, it doesn't matter if they're not known, they're not going to get a notice. But nevertheless, they're required to file a creditor's claim within 4 months of letters being issued. If they don't do that, it's all over. So there's more finality. There is no such claim process with a spousal property petition. So if you were concerned that the decedent had lots of creditors and it may be better to get closure and finality on the creditor side, you might file a full probate instead.
One of the things that's interesting as a real estate agent, I'm literally dealing with this today in a couple hours. When a buyer's buying a property and you ask them, well, how are you going to hold title? They don't know. I'm not an attorney. I'm not allowed to give them legal advice, though I can send them marketing material from an attorney or from a title company that lays out what their choices are and why they might want to make the right choice. And oftentimes people say, well, it doesn't make a difference. Joint tenants or community property, what's the real difference? But there is a difference. Talk a little bit about the difference when a married couple buys. What are the differences in terms of survivorship or transfer of property, or maybe it's not important and it's overstated. How important is specifying for a married couple joint tenancy versus community property or not, or separate property if they maybe have a prior marriage situation?
Yeah, titling is one of my featured topics when I'm giving talks and when I'm talking to clients. I mean, the vast majority of our clients, since we do a lot of estate planning, excuse me, in addition to probate, we're forming, helping clients establish living trusts and living. If you own property and it's titled in a living trust, then you get a pass from probate. So it's typically the best way to hold title. There are some exceptions, but let's say somebody didn't want to, married couple, they just didn't want to do a living trust or hadn't gotten around to it. So they said, well, we'll get to that soon. And but meanwhile, when you close escrow, you have to, and many real estate agents are asked by their clients. The sort of the responsible thing to do would be to say, if you're a realtor, is to say, I can't give you specific advice about that, or I'm not supposed to, because I'm not an attorney and it has important legal and tax ramifications. CAR form, purchase and sale agreement, has got in bold, as everybody knows and has for years, it says, hey, the manner of taking title has serious legal and tax ramifications. And it does. So the joint titling in California, at least, there's in other states, there are some different forms of holding title. There's tenants of the entirety, and there's some other forms that don't that aren't here in California. But in California, there's joint tenancy, there's community property, with rights of survivorship, right of survivorship, and then there's tenants in common. And basically going through tenants in common is undivided interest. So if you own a tenants in common, you have an undivided 50% interest with whoever the other tenants in common are. If you do that with your spouse, that's usually the worst way to hold title, because it pretty much guarantees a probate. There's no right of survivorship. There's no sort of automatic transfer when one tenant in common dies. Tenants in common is very appropriate if you take title with a friend or your brother or sister or a parent or whatever, because each party wants to be able to do whatever they want with the asset when they die. So if you have a will and you have tenants in common, you can will your 50% to whoever you want. So there are tenants in common has a place, but it's very rare that would be. I can't think of an instance where that would be advantageous for a married couple. You really want something with right of survivorship. What does that mean? It means that upon the death of the first co-owner, and here we're talking about spouses, there's sort of an automatic, by operation of law, automatically the surviving co-owner owns the interest that was held by the deceased co-owner. That's only possible with two forms of title here: community property with right of survivorship and joint tenancy. And so it doesn't mean it's absolutely 100% as soon as the person dies, you own it. You have to file a form, but it's perfunctory. There's an affidavit that gets filed with a death certificate, and then title is cleared in the name of the surviving spouse. So it's pretty easy and straightforward. There's a catch with community property. Here, you can hold title as just community property. That doesn't hold with it a right of survivorship. So if a married couple holds title just as community property, but it doesn't have that tag, right of survivorship, then it's going to require a spousal property petition, all that cost and inconvenience, just because they didn't specify on the title with right of survivorship.
Wow. Well, I didn't realize that. Well, thank you for clarifying that. That's important. And of course, you ask the customer this question when they're faced with like 2 million pieces of paper to sign and review, and they're liable for every single word of every one of the 2 million pieces of paper. And you know, as an agent, you can't say, well, this is what's really important. Of all that stack, this is the one to get right. But part of me wants to say, from a business point of view, that's one to get right. Make sure you have the right. You know, in some cases, people don't want to have survivorship. Maybe there's a prior marriage and they have kids they want to provide for from the prior marriage, and so that's not the appropriate way. Good reason to get an estate plan. Good reason to have a trust rather than leave it to the deed. But that said, and the other thing, just to add a little mustard on your comment, you're gonna take title as something, right? If you're gonna buy the property, the escrow at the end of the day is going to put something. I'm sorry about that. My do not disturb expired. You're gonna get a deed from the seller to you, and so the question is, well, what's it gonna say? And you know, I've been in court where people bought property over bids, and the judge will say, how you can take title? And they say, well, just Bob and Mary Smith. Okay, but how do you want to take title? And the judge can't give it legal advice, and you know they're taking it wrong. They're going to get a deed that says Bob and Mary Smith, and that's probably not really what they want at the end of the day. So thanks for all that.
Yeah, just to interject, Bill, about that. Yeah. Bob and Mary Smith, somebody who's attending this might say, well, you didn't say anything about just the names, Rob. You said tenants in common, joint tenants, etc. Bob and Mary Smith, that's deemed to be tenants in common. If it doesn't specify, the default is tenants in common.
Which I think is the worst of always, the whole title. As a real estate agent, that's the most problematic because you have no survivorship issues, you have tax implication issues, reassessment issues. You might have legal issues on who gets to make decisions, who gets to live there. I mean, it just really opens up a can of worms that, you know, certainly can be prevented with proper planning. But when they just say, oh, just Bob and Mary Smith is fine. Whew. And as long as you get along with your wife, I guess it's all fine. As long as you're both alive, you know, it's great. It's only a problem when it becomes a problem. So,
and just another point is that a lot of title companies have this chart and this matrix, and it's complicated. And they've got on one side the forms of holding title, and the other kind of the various implications. And you read it, and your eyes, you know, twirl around in your head, and it's very difficult. I mean, yes, it's better than not having any instructions or any information. I years ago thought there's got to be a better way, so I put together a digital brochure on the various forms of holding title in California and the pros and cons of them. Anybody who's listening here can is happy, you know, watching can send me an email, and I'd be happy to send them. Doesn't cost anything, just happy to send them my digital brochure on the manner of holding title and a brief summary of the pros and cons.
But of course, the best alternative is make sure you get it right when you buy the property, because the other thing that happens is, well, we'll just do it now this way, and then we'll fix it later. Sometimes they don't fix it later. That's, I think, sometimes a Hegstead petition. Well, we meant to fix it, we forgot to. Or B, it's not insured, and you kind of lose the advantage of the title insurance. Not that it's be all end all, but you're paying for it. Why not get that transaction insured so there's no question who you meant to send it to? Excuse me. Okay. Next topic I want to run by you is the new $750,000 threshold, AB 2016 Streamlined Probate. A lot of fanfare was passed. How active do you see that actually in the marketplace?
Well, it's a brand new law, or relatively new. It's new as of 2025 in February, at the end of February of 2025. New law passed in California that was designed to sort of streamline and make a lot less expensive and a lot less bureaucratic the process of transferring on death a piece of real property. If somebody dies and substantially, and they only have a property that was a principal residence and is valued at date of death of $750,000 or less. We know California is expensive in general, and that doesn't work with a lot of properties. But there are lots and lots of properties still in California that are not worth more than $750,000. If that's all or substantially all you have and you die, there is an expedited procedure where the essentially it's done by valuing the property. You get a probate referee who's basically like an appraiser who is associated with the county in which the person died, and you have them do what's called an inventory and appraisal that just says, okay, this 123 Main Street in wonderful city was owned by the decedent, and the appraiser or the probate referee says yes, it was worth $650,000 on date of death. You take that inventory and appraisal, and there's a form that gets filed and signed by the rightful successors. That could be the people in a will who it's a valid will that was signed and says my property goes to Betty. Then Betty signs the affidavit and files that in probate court with the inventory and appraisal showing the valuation, and that effectively is the end of it. And that again serves as evidence that concrete, definitive evidence that Betty is the new owner. And so it can be very useful. The catch, or one of the catches, is it's got to be principal residence. It's got to be under $750,000. And if let's say there's bank accounts and there are investment accounts and other assets, automobiles, and all that is, $300,000 or $400,000 or $500,000. Well, then you have to do a probate for those assets, and at some point let's just throw in the real estate and do a probate with all this stuff, or you can do an expedited probate with the principal residence for under $750,000, and you can do a smaller probate. So all told, it's going to be less expensive to do that. If you have less than $208,850, it's a weird number. So let's just round it off and say if you have an aggregate of less than a couple $100,000 of other assets, then you can do what's called a small estate affidavit for that property, and you can do the expedited probate for the $750,000 or less real estate. So you have to sort of look at all of the various assets, but when it fits, it's much quicker and much less expensive than doing it's sort of like another option. You've got, full probate, you have spousal property petition. When that fits, you have a expedited probate with the $750,000 or less, and then you have this small estate affidavit, which can't involve real estate. That's just miscellaneous kind of personal property. So it's like a puzzle, and you just make sure that the pieces work. How do the pieces work best for the client to make sure that the process and the costs are sort of minimized?
I know when this was passed, there was a lot of excitement. A few attorneys in particular were putting together fixed price options for this and some streamlined procedures for this, and anticipated, but I just don't think I've seen that many of them. And the attorneys I've talked to, I haven't talked to anybody who's done one yet. I've seen some that started, and then there were hiccups along the way that prevented it. But it seems to be one of those things that it sounds great in practice, but there's not that many that fit that bill here in California.
It's true. I have a very, very active probate practice, and I'm doing a few of them, but not. You would think, well, this is going to be very prevalent because it's such a great thing, and it is when it fits. But and I started one actually a couple months ago. The client was quite sure that the property, a lot of deferred maintenance, that the property was worth less than $750,000. We sent it to the probate referee. I said, I'll try it. No guarantees, and I'll bill you on an hourly basis for it. And it's not going to be all that expensive because there's not much in the process. And the appraisal came back at $875,000. Right. And my client said, well, can you go back to the probate referee and maybe have them adjust it to lower it? And I said, yes, give me a list of all the defects and the problems with the property.
Right.
And ultimately, the bottom line is the client threw his hands up and said, Rob, there's no way that we can list enough defects that's going to lower it that much in value. We don't really have any choice. Let's just go with the full probate. You warned me, Rob, that we may have to do that. Right. So sometimes you don't know until you run it by the probate referee and get the inventory and appraisal. So that's another issue. And that can be a little bit in time and cost before you even know whether or not you're going to qualify for this if it's going to be close.
Well, I will say to the real estate agents listening, this is a chance to help out because the inventory appraisal report probate referee theoretically does a drive-by only. Like they don't get access to the inside. I mean, I'm a disparaging organization, but I don't believe they actually drive by the property. There was a time when they would charge extra for photos, and it'd be like $50 or $75 in the old days. And I saw that, up until recently, it seems like it just stopped, and I'm not sure exactly why. But I don't actually believe, in my experience, and I'm not here talking about any particular case, they actually do drive by. And so it creates opportunity that if we have good information, give it to them before they do the report.
Yes.
So if we can show comparables and we show how much nicer they are and how much it would cost to get to that level, then you can give that to the referee beforehand. And I find most of them appreciate they're listed publicly if you know the name, or when they file the probate, the name of the probate attorney, probate referee is on the form. You can find who they are and coordinate that with the attorney, obviously, and your client. But you can cooperatively send them information ahead of time. And I think this is one of the opportunities of realtors we have to create some extra value, because like in your case, if it was true that you can get them to come below, not doing anything nefarious, I'm saying right. Just give them comps, give them pictures, show the photos of the comparables with the beautiful kitchens and the views, and then your house that's fallen apart. You're saving your customer way more than your commission. That's really where you earn money for our customers, I think.
100%. That's a great comment. There's no reason whatsoever not to provide the information before they do that. And you can always supplement that with even additional information. And you're also very right on drive-bys. I don't. I'm sure some do it, but as a percentage, it's very, very rare that where they actually take the time to do it. I mean, to their credit, the information that's available is so robust that probably a lot of times there's not a big need for them to drive by. And what are you going to get from driving by? You may get some information, but it's limited. The only really effective way to determine if there's substantial defects and so forth is to actually go visit and go in the property. And I can tell you that doesn't happen, or that's extremely rare.
Yeah, in the old days, you didn't know if the house next door was a crack house or
right.
heavy traffic just by the address. Nowadays, with Google Maps and MLS, you can really hone in and see most of those. And so, again, I don't know that probate referees need to drive by, but we as real estate agents, if we know, we've been to the property, we know more, the opportunity is to share more information. And I think at the end of the day, more information helps everybody. One of the lessons I wanted to chat about a little bit, because I know you have a lot of experience with this, is special administration, right? There's the normal case, you file a petition either for full or limited authority, and it takes certain time, and there's defined rules. But there are times when you can't agree on who's in charge, or you can't wait to get somebody appointed for all the authority, but something specific has to be done. Talk a bit about the tool of special administration and how you can use that to help protect an estate.
Yes, special administration is a very important tool. And essentially, when you file a petition for probate, that is we call sort of general administration. And that requires a noticed hearing. And most of the courts in California are sort of undermanned and don't have enough support. And so what happens is the time between the filing of the petition for probate and the hearing, where if it's approved, letters of administration are issued, which really starts the probate and authorizes the personal representative to do things like sell the real estate and take control of the assets and really start it materially is a long period of time. 2-3 months at least, but some courts are even further out than that. So there are times when, let's say there's a reverse mortgage and there's a foreclosure notice or a foreclosure.
It never happens.
Right.
I have a whole podcast on this topic, by the way, a whole separate podcast. Reverse mortgages. I'm sorry, go ahead. But yeah, that happens regularly.
Yes, it does. It's common. And so there just isn't time. And so so when you file the petition for general administration, this sort of normal petition for probate, there's a box to check, special administration. And then there's some attachments. And essentially you explain to the court why there's some urgency to get this heard and to allow your client, as my client, as the proposed personal representative, to have certain powers early. They can't do everything that you could do because that would be just the general administration. That requires a noticed hearing. But you can take control. For example, you can ask to take control of the real estate, to get it sold because it has a reverse mortgage, to be able to pay bills and creditors, and to manage the property that has tenants in it. There are so many different situations where there's more urgency. There's a squatter in the property, or there's been damage done by derelicts in the neighborhood, and somebody needs sooner rather than later to actually have authority to go in and take control. So you spell out the particular powers that you are asking for, and you can do that on an expedited basis. Different courts have different periods of time and different processes, but essentially you can usually get that done in a shorter period of time, as a week or a few weeks, as opposed to waiting 3, 4, 5 months for a general probate hearing.
And so that's appropriate for foreclosures, I think, is the number one most common example I see of that. Managing property, collecting rents, paying bills, paying mortgages. I think running businesses is another one I see occasionally, where I have a case where the petitioner had to make payroll and collect money and transfer accounts and such, and so the court allowed them to do that. Of course, you have to have a bond, and there's other protections that the court's going to impose and things like that. So, well, look, Rob, I really appreciate a chance to kind of get into some details. You obviously are very experienced in these matters, and to get into some of the little weeds a bit, nuances. I appreciate it. I know I learn quite a bit when I speak to you, and I hope on behalf of the people who listen as well do. Best way to get in touch with you, if somebody wants more information or to engage your firm for probate or related material, silvermanjaffe.com is the website.
Right.
And up front, we have also the phone number as well as contact information. Robert, I just want to thank you again so much for being available today to share with us. Again, you've been so kind with the time overall in the past. And happy holidays and continued success, and we'll talk to you soon.
Always enjoy it, Bill. Thanks for having me, and happy holidays to you and the folks who are attending as well.
Thanks so much. And for this is Probate Weekly. We get together every week and issue a new episode, usually with probate attorneys like Rob Silverman. Well, actually, not often as good as that and with much detail, but try to learn to be better at our craft, whether it be for attorneys or real estate agents or vendors, how to be more successful helping our customers. If I can help, please like, subscribe, reply, email. If you have suggestions for topics and or guests, let me know. I'm at Bill Gross Probate. As always, make today your best